eyes are not working. No, I wouldn't go. Just give me a prescription. Good morning. Are you Jamarian Martin? Speak up, please. And will your client waive the formal reading of the indictment?
Will, Your Honor.
Mr. Martin, in cause number 25, DCCR 0196, you're charged with the state jail felony offense of burglary of a building, and that's from October 3rd of 2024. And how do you plead to that charge?
This hearing starts quietly, but don't let the calm fool you. In criminal court, the very first moments often reveal everything. The defendant's attitude, the judge's patience, and whether the case will move smoothly or spiral into something far more complicated.
Are you pleading guilty freely and voluntarily?
Are you pleading guilty freely and voluntarily?
Do you understand what's going on?
I do.
You do? Huh?
That's what I do. That's all.
All right. So, are you entering your plea freely and voluntarily? Did anybody make you plead guilty?
This hearing starts quietly, if the defense will waive don't let the formal reading of the indictment. In criminal court, that's a standard procedural the very step. First moments, normally the court reads the entire charge out loud. Defendant's attitude, but most defendants waive to speed things up, and whether the case will move smoothly or spiral into something far more complicated.
No. I can't. Huh?
I said open freely voluntarily.
He said freely and voluntarily.
Okay. Has there been any issues, Mr. Parker?
There hadn't been, Judge. No.
Mr. Martin, if I test you this morning, you can have something in your system?
Not sure.
You're not sure. Have a seat in the jury box. Let's find out.
2 weeks ago.
Tell the truth. Because what's going to happen is I'm going to get amounts, the levels, right? So tell me the truth. When's the last time you smoked?
This hearing starts where things get interesting, but don't let the judge suspect the defendant might be in criminal court during a plea hearing. The very first moment that's a serious often reveal issue. Everything. In the eyes of the law, defendant's attitude, a guilty plea must be knowing, voluntary, and whether the case will move smoothly or spiral into something far more complicated. The entire plea could be invalid.
That's the truth. Have you done anything else? Speak up. Promethazine? When's the last time you did that?
2 days ago.
What is that?
Cough syrup. Anything else with that?
Judges, obviously, up to the court's discretion, but we're definitely going to reserve the right to dismiss the ISF properly substance abuse track.
How old are you? 19? All right, so I guess what I would rather do, I want to go ahead and get the process going if he's got a plea agreement, but I think based on his age and the nature of the type of drugs he's using, I am going to raise that bond. We'll get the pre-sentence report done, see if there's any issues with regard to substance abuse, and if there's any up front that...
This hearing notice how the judge starts digging deeper. Don't let the drug fool you. That's not just curiosity. The very first about assessing credibility and competency. The defendant's need to know whether the defendant fully understands the consequences, and whether the case will move smoothly or what they're about to agree to far more complicated.
Treatment that I find necessary at that point. So let's go ahead and go through the plea. And will he waive the formal reading? I know we started it, but we're going to go back.
Pled guilty. He said freely and voluntarily, and that's about where you left off.
All right, and so did you plead guilty to this offense because you actually did what they charged you with? You didn't? You didn't do what they charged you with? Look at me and pay attention, all right? Okay? Everything's going to be okay, but you're young, and if you're going to be successful on any kind of probation in life, you're going to get some help early on right now so that you don't end up with a felony conviction, okay? But I need you to pay attention to my questions and listen very carefully and answer them. So, you're charged with burglary of a building. The question I asked is, did you plead guilty because you actually did that? Okay. I have here on the computer some documents that have your signature on them. Before you signed these, did you go over them with Mr. Parker? Do you fully understand them? Just pay attention to me right now. Do you understand the papers that you signed on the computer? And do you understand, if I follow the agreement that you made with the district attorney, that you will be waiving or giving up any right to appeal? So if I go along with this agreement, you can't change your mind later. Do you understand? And it looks like the agreement's for a 4-year deferred probation, that there would be restitution ordered, which means you would have to pay back some money for any damage or whatever you stole, and they'll figure that out before sentencing. Is that your understanding?
This hearing starts quietly. He's only 19 years old. Don't let the calm fool you. Atmosphere in criminal court shifts. The very first moments often weigh heavily when deciding punishment. Defendant's at that age, the judge's patience, the justice system, and whether the case will move smoothly or spiral into something more on whether there's still time to redirect someone's life.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1. It's admitted. Is there any evidence that Mr. Martin is not competent?
No, Your Honor.
All right, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, but I'm going to reset your case for sentencing so we can get a pre-sentence report done. If possible, I'd like to get some type of substance abuse evaluation done and any recommendations as well.
This hearing starts quietly. Is incredibly important. Don't let the calm fool you. The defendant just indicated criminal court he didn't actually commit the very first moments, yet he previously said he was pleading guilty. The defendant's contradiction sets off alarm bells for any judge, and whether the case will move smoothly or spiral into something far more complicated.
As we'll get that restitution figured out, and then we'll come back later for sentencing. Based on the nature of the plea, based on your age, and the fact that you tested positive for THC and admitted to using promethazine, I am going to raise your bond in your case to $100,000. If you make that bond, a condition of it is that you have a drug patch on at all times. So probation's going to come out to the jail, talk to you. We're going to figure out what all you need, and then we'll get you hopefully started in on this probation where you can be successful. All right? Go back with the bailiff.
Thank you.
Thank you.